Well, good afternoon, everyone. Thank you very much for joining us again. I think the floor is yours, Mr. Dennis.
It's of course morning our time. My lords, if I might.
Yes, do forgive me. Good morning, Mr. Dennis.
My lords, if I may pick up where I left off yesterday. I believe when we took the break, I was seeking to address an issue raised by my Lord Briggs in dealing with a hypothetical which he raised, and he posed the question as to whether, having regard to clause 10.3, your lordship should recall that is the clause which speaks about the party seeking performance relief taking steps to minimize loss and damage. His lordship was asking whether, in the context of that clause, the appellant couldn't, upon the closing of Havensa, have approached the respondent to seek to negotiate a price increase with a view rather, to making their continued supply to the appellant economically viable, thereby minimizing the delay, the loss or damage contemplated by that very clause, and whilst in the meantime temporarily continuing to supply from another source. And I was in the process of answering that hypothetical, and I began by saying, in theory, yes, they could, but in fact, and I will demonstrate to your lordships, that is not what happened in this case. Instead, my lords, what the evidence actually shows, and what the learned trial judge found, is that upon the happening of that event, the appellants made a conscious commercial decision not to permanently suspend supply. In other words, effectively not to exercise its right to terminate the contract, but instead to continue to perform using a new loading point or facility in Antigua without ever suggesting to the respondent that this was a mere temporary measure pending negotiations between the parties on a price increase. Only later, after having already made the decision and communicating it unequivocally to the respondent, did it seek to engage the respondent on the issue of a price increase. So that it was after that, when the respondent refused to entertain the idea of a price increase, that it purported to seek permanent performance relief, that is, a complete cessation of supplies to the respondent based on the Havensa closure, which had occurred, or notice of which they had obtained some 6 months prior. I will take your lordships to the evidence which makes good this point, and on which the learned trial judge relied to come to her conclusion that there was indeed an election, and that the question of seeking to negotiate a price came after that election had been made. So that the notion, the evidence does not support the notion that all that the appellant was seeking to do was to minimize loss and damage by engaging the respondent in those discussions. I will take your lordships first to the written evidence by way of correspondence. And I would like to begin, my lords, by taking your lordships to the notice of the closure itself, which your lordships will find at page 929 of the bundle. Now, your lordships should note that despite how momentous a development the imminent closure of Hovensa was for the contract, despite how momentous a development this was for the respondent, the appellant did not bring it to the respondent's attention when it received it in December, on December 1 of 2014. It is dated that date, and your lordships will see that it in fact refers to an earlier conversation on that very day with the appellant's president, Mr. Esposito. Mr. Esposito, in his evidence at EB 573, himself confirms that the notice was received on the 1st of December. So there can be no doubt that they had the benefit of this notice. They knew of this imminent closure from the 1st of December of 2014. It is significant to note, however, my lords, that this was not brought to the appellant's attention at that point.
To the respondent's attention. Yes, Lord Leggett.
There is in clause 10, subclause 3, a requirement that the other party was timely notified of the event or likelihood of the event.
There is that.
But am I right to understand that no point was taken that there had not been timely notification? No point has been taken by your client?
Not in that way, my lord. The significance of the fact that notice was not given at that point and was not given actually until a month later, until 2 months later. The fact that it was not given until 2 months later, the 28th of January, the significance of that, my lords, is that it belies the notion that upon becoming aware of the imminent closure, the appellant was interested in doing anything to minimize that loss, and that what it was to minimize any potential loss, and that what it was doing from then on was efforts to ensure that it complied with clause 10.3, meaning that it should take steps to minimize losses. Because going back to the hypothetical raised by my Lord Briggs yesterday, if it was that that was the approach which the appellant was taking, it is incomprehensible why at that point, upon receiving the notice, it did not immediately begin to engage the respondent to say, look, we've received this notice. It has implications for our ability to supply. We may be able to continue to supply from another source, but only if you're prepared to entertain some adjustment in price. And we are doing this in order to...
Yes, Lord Sales, please.
Yes, Mr. Dennis, I was looking at the reference you gave us to page 573 in Mr. Esposito's evidence. It seems from that after the notice was received on the 1st of December, the appellants were hoping that they might secure a reversal of the decision to close the Hovensa facility by going to the US Senate. And I think I picked up from the papers that they in fact sought to recruit your clients in that endeavor. So wasn't the position that there was some discussion about what was happening at Hovensa, and the joint hope of both your clients and the appellant was that the US Senate might be persuaded to change what was happening?
Well, my lords, the parties on both sides were well aware of that possibility from the time when the contract was being negotiated. So the Senate hearings into that eventuality was not something new, of which the appellant was only then learning, and then engaged the assistance of the respondent to assist in the endeavor to seek to persuade the authorities in the US Virgin Islands that the closure should not happen. That was the position from the stage when the contract was being negotiated. But the fact that a notice was issued on the 1st of December moved things to a much more critical and urgent and immediate stage. This heralded and signified an imminent closure. Therein lay the urgency to engage the respondents, if indeed the appellants wished to set about seeking to address matters which would enable them to minimize any delay or damage which would have been caused by clause 10.3. So,
but I'm sorry, Mr. Dennis. Theoretically, it would have been open to Delta, surely, to explore the possibility of restoring supplies to them at a rate that was equivalent to Hovensa, and it didn't need, therefore, to have recourse to clause 10 of the contract at all. I mean, surely it's entirely a possibility. It's not incumbent on them, as soon as it receives notification on the 1st of December 2014, to immediately contact your client, is it?
They could have done that, my lord, certainly. The point is that they did not. They did not.
They did not what?
They did not seek to engage our clients.
Yes, Lord Leggett.
On the issue
Mr. Dennis, can I just confirm, am I right to understand that your clients have not advanced an argument in these proceedings that there was a failure to take reasonable steps to minimize damages, and that for that reason, performance relief was not available?
No, my lord, we are not advancing that argument. We are not advancing that argument. We are simply saying that being confronted with this imminent closure, which gave them an undisputed and acknowledged right to permanently withhold supply, it did not exercise that right. It chose to do something else. It chose instead to seek an alternative source of supply.
Well, what's wrong with that?
Continue to perform the contract, and only.
What's wrong with that? I mean, surely under the terms of the contract, it was open to Delta to see if it was possible to find an alternative source of supply that would allow them to continue to perform the contract. I mean, I can't see what's objectionable about that.
We're not saying that that is objectionable, my lords. What we are saying is that by doing that, by identifying that alternative source from which to continue to supply, from moving to a new loading port and continuing to perform, it thereby affirmed the contract. It affirmed the contract by taking the steps.
So you say that by engaging in investigation as to whether they could get an alternative source of supply, that in effect constituted an election on their part. Is that what you're saying?
My lords, not by seeing whether it could find an alternative supply. The election comes about by virtue of the fact not only did it seek a new source of supply, it identified a new source of supply, continued to supply from that new source, and in its correspondence to the respondent, made it clear that they were continuing to perform the contract from this new source of supply. Hovensa was no longer a source of supply under the contract. There was a new source of supply under the contract. And the evidence of the respondent's own witnesses makes it clear that by the end of February, Hovensa was no longer a source of supply for the purposes of the contract. They had moved on from Hovensa. So Hovensa and its closure and the consequences of that were no longer in the picture. They had solved the Hovensa closure issue by moving on to a new loading point, a new loading port, a new facility. So they were continuing to perform their contract on the basis of a completely new facility. Hovensa was no longer in the picture. So the point, and my lords, and the respondent's position is that with the whole issue of Hovensa having fallen away, and with they now simply performing the contract in its terms based on what was their new permanent loading port, they could not then 6 months later seek to rely on the Hovensa closure, which by now was spent as a basis for seeking performance relief. In other words, Hovensa could no longer be an excuse for their failure to perform, because that problem had already been solved and was out of the way. They had a new loading port in Antigua, and there was never any suggestion that there was any difficulty or any issue arising from that new loading port, which made their continued performance of the contract impossible or unsustainable. If it were, my lords, that having identified this new loading port in Antigua from which it was now operating instead of Hovensa, it ran into some difficulty in maintaining those supplies because the Antigua source had dried up or that Antigua source had closed or whatever, it would have been open to them at that stage to seek performance relief based on this new eventuality. What it cannot do, what it was not entitled to do, we say, my lords, is to seek to revert to the Hovensa closure, which was no longer an issue, as a basis in June 1, 2015, some 6 months later, to use that as a basis for seeking to get permanent performance relief and in effect terminate the contract. That, my lord, is the essence of our analysis and of our position.
Yes, well, I think we have that point, so let's move on.
Mr. Dennis, as I understand that point that you're putting to us, you're saying that the conditions of clause 10 were no longer satisfied once the source of supply had been switched from Hovensa to Antigua. But there was no finding made by the judge to that effect, was there?
No finding to what effect, my lords?
No finding by the judge that the conditions of clause 10 were no longer met There was no continuing interference with supply or storage or anything of that kind.
The learned trial judge did find that by June 1, they could no longer rely on the Hovensa closure as a basis.
Election, there's no other reason given. Only election. Isn't that right?
Because by that point, my lord, Hovensa was no longer a source of supply. That was the judge's finding. The judge accepted the evidence, part of which was that by February, by the end of February 2015, Hovensa was no longer a source of supply. That was Mr. Esposito's own evidence. The learned judge went through that analysis and concluded that as at that point, it was too late for it now to be relying on that closure because it was no longer a source of supply. It had fallen away. And my lords, if I may attempt to take your lordship to the judge's analysis on this. Yeah. The learned judge, my lords, deals with this at paragraphs 53 onwards of her judgment, where she deals with the court's analysis on issue 1.
Just give us a page number, please, Mr. Dennis.
My lords, the judge's analysis begins at page 320.
Thank you.
And beginning at paragraph 59, she begins with the Hovensa closure, and she comments on the fact that this was not communicated to the respondents until some 2 months later. Then her ladyship goes through the correspondence. She deals with the fact that in January, even after becoming aware of the imminence of the closure, it did not seek to invoke its rights under the contract to effectively terminate. It goes on to deal with the other, she goes on to deal with the other correspondence. Deals with the fact that the appellant was treating and described the Antigua source as its new loading port. And then she goes on at paragraph 70, by the time March 2015 rolled around, it is clear that the defendants are still loading in Antigua. And then at 72, she says, from the way the correspondence evolved, it is clear that the defendants, for the very first time, sought by letter dated 15th May to inform the claimants that the continued supply was always linked to a minimum contract price. And then she speaks about the respondent, or rather the appellant, on June 1st, not having received a favorable response to the overtures, to the belated overtures for renegotiation, sought to terminate the contract. And then she goes on, my lords, at paragraph 85, after going through all of that analysis, which I will not go through in detail at this point, I will in relation to another point later on. Eventually, my lord, she concludes at paragraph 85 that by the 1st of June, the defendants, having elected to retain the contract and continue to supply, despite its eventual discovery that the same was uneconomical and unprofitable, could not then seek to rely on the Hovensa closure some 4 months earlier, which had given rise to their right. Now, this paragraph does not stand on its own. This paragraph was the culmination of a look by the learned trial judge at the evidence which included the fact, which included the evidence that at June, when this purported termination was taking place, Hovensa was no longer a source of supply. She had the benefit of Mr. Esposito's own testimony that Hovensa was no longer a source of supply.
I mean, is Hovensa's being no longer a source of supply inexorably connected to an election on the part of the appellant? It doesn't seem to be.
Your Lordship, kindly repeat.
Yes. Is the circumstance that Hovensa was no longer a source of supply inexorably connected to an election on the part of the appellant? I mean, surely it's open to the appellant to say, well, Hovensa is out of the picture, but I'm going to try and find some alternative source of supply that will allow me to continue the contract. But I'm certainly not electing at this stage to continue the contract irreversibly. But when it discovers that no alternative source of supply is available, it's then entitled, is it not, to invoke clause 10.
What we are saying, my lords, is that the ability to invoke Hovensa as a basis for permanently suspending supply is not boundless. It's not limitless, because at some point the appellant needs to make a decision. It needs to make a decision because confronted with a situation where it has a right which it can, without dispute, exercise, namely to terminate supplies because of this eventuality of the closing of Hovensa. It needs to decide whether it is going to do that or not. It needs
I'm sorry to interrupt. I'm sorry to interrupt, Mr. Dennis, but I need to be clear as to the import of your submission on this point. Do you say that as soon as Delta became aware that Hovensa was not going to be a source of supply, it either had to elect to continue the contract or forthwith to have recourse to its rights under clause 10? Is that your submission?
Well, no, my lords, I'm not saying that they had to elect immediately. I'm not saying that they had to elect immediately. Your lordships have indicated and suggested that there would have been nothing wrong for Delta seeking, consistent with its obligations under 10.3, to try to do something to salvage the contract. Now, had it done that, when it became aware of the imminent closure, the issue of an election would not arise because it would have been engaging the respondent to seek to do that. However, our simple point is that that is not what happened. Instead, it proceeded to seek a source of supply without any engagement of the respondent. It identified that source, continued to supply that source. Hovensa fell out of the picture. And with Hovensa having fallen out of the picture, and it continuing to supply from a new source which it had identified, having identified a new port from which to supply, and supplying the respondent on that basis, and notifying it in its correspondence of the new regime, namely the new port of supply from which it would continue to perform. That it is at that point that the election, we say, took place. Not that it had to make the election the moment it became aware of the imminence of the closure. What we are saying is that even if it didn't do that, and it was not compelled to do that, by its course of conduct thereafter, it made it clear, it demonstrated that it had moved on from Hovensa and was performing the contract from a new source. That is not to say, my lords, that it could not have approached the matter differently. And instead of, that is not to say it could have approached the matter differently by engaging the defendant, the respondent from the beginning. But it did not do that. So the election, we say, they were not compelled to make at the outset, but at some point it needed to make an election. And as the authorities show, my lords, the whole point of the principle of the doctrine of waiver about a party being well aware of its rights, it being necessary for them to determine what to do, it's because the other party needs to know where it stood. So the BVI Electricity Corporation needed to know where it stood in relation to its supply of fuel under this contract. So at some point, Delta had to decide what it was going to do by making an election. And what we say, my lords, is that the chain of correspondence clearly demonstrates that certainly by mid-February, it had established a new source of supply from which it was continuing to perform. And so it was too late in June of 2015 for it to seek to rely on Hovensa when that was a completely spent issue. It was no longer a source of supply.
Right. Well, I think we've made enough of that point. Perhaps we can move on to the next one.
Yes. Very well, my lords. So I was taking your lordships through the documentary evidence to make good the submissions which I began with. I've already taken your lordships to the notice of the closure. Then I would like to take your lordships to the letter of January 27 of 2015. And this, my lords, is the first communication which the respondent received from the appellant after received notice of the Hovensa closure. And this was...
I think that's at 933, isn't it?
931, my lord, the letter of January. There were two letters dated January 27. The first one I will take your lordship is at 931.
Yes, thank you.
Now, this letter, my lords, we say is significant for two reasons. And just to look at the letter, my lords, if I could take you specifically to the third paragraph, where it says, given constraints relating to weather conditions with winds more than 25 knots, the tanker had to be diverted. While in the process of diversion, adverse weather conditions. So this was a letter in which it was seeking performance relief on the basis of weather conditions, not on the basis of the Hovensa closure. It's still silent on that and on the notice, weather conditions. We say this letter is significant for two reasons, my lords. First, because it evidences the appellant's decision not to permanently suspend deliveries, that is, to terminate the contract on the basis of the Hovensa closure, as it was entitled to do. So much so, my lords, that it is seeking performance relief for a reason unconnected with the Hovensa closure, namely weather conditions. The second reason, my lords, why we'll say this letter is significant is because there is nothing in it to suggest any interest on the part of the appellant in engaging the respondent on issues of price with a view to making its continued supply viable so as to minimize damage likely to be caused to the respondent. Again, my lords, bearing in mind clause 10(3). And so the letter is significant for those two reasons. The next letter I will take your lordships to is the second letter, which is dated January 27, and that, my lords, is at page 933.
Yes.
This letter, my lords, is seeking performance relief for a delay in supply, which it attributes to the notice of the closure. So this is the very first time when it is alerting the respondents to the notice of the closure. But again, my lord, there is nothing in this letter to suggest any effort on the appellant's part to do anything by way of engagement of the respondent with a view to minimizing damage having regard to clause 10(3). It's a simple request for performance relief from the consequences of delay which were attributable to the move from the Hovensa facility by the end of the month.
Yes.
So it is significant, my lords, for that reason. No engagement. So the question of it taking steps or seeking prior to moving its port of supply to do things to minimize delay or damage simply does not arise in the context of this correspondence. Next, my lords, I will take you to the letter of January 28, 2015, and that your lordship will find at page 936.
Yes.
Now, this, my lords, is the letter in which 2 months later, Delta finally forwards a copy of the notice to the respondent. And your lordships should note that although it speaks in very vague terms of wanting to schedule a meeting to discuss the contract and the implications of the notice, there is nothing in it, absolutely nothing in it, about specifically wanting to discuss price as a basis for maintaining the viability of its continued supply to the respondent as a means of minimizing damage to it. Again, bearing in mind clause 10(3). Now, my lords, it is being contended by the appellant that this letter made it clear that it was seeking a variation of the contract by virtue of the imminent closure of Hovensa. However, my lords, the letter does not say so. And we say, my lords, that it is in such vague terms as not to be able to admit of that interpretation. One cannot read into this letter something which is simply not there. It is also significant to note that there was no follow-up on this letter by Delta itself to pursue any discussions relevant to price until long after it had, in fact, we say, by its conduct, elected to perform the contract rather than terminate it, and had also communicated that election to the respondent. The next letter of significance to be considered, my lords, would be the letter of the 2nd of February of 2015. And that your lordship will find at page 937.
Mr. Dennis,
My
sorry,
lord.
just on the point, the factual point that you just made, that the question of a price increase wasn't raised until long after the election to continue. I wanted to draw your attention to paragraph 11 of the judge's judgment, if I may.
Paragraph 11, my lord.
Yes. It's going to be about 309. Forgive me. Not 309, 311. Where the judge says the claimant and the defendant commenced discussions on or about February. And during the course of the discussions, the defendant requested an increase in the contract price.
I'm reading this paragraph, my lord.
Yes. So I was rather reading it as a finding by the judge that there was a debate on the 6th of February and thereafter in which the appellant was seeking an increase in the price.
My lords,
With that.
but my lords, I was going to take your lordships to that letter of February 2 in that context, my lords, because this has to be viewed in the context of the previous correspondence, which I was about to take your lordships to. Now, if I might do that, my lords, because I was going on to the February 2 letter. In this letter of February 2, seeking performance relief for a shortfall in the fuel below the 10-day minimum, the respondent, or rather the appellant, attributed that shortfall in its supply of fuel seeking performance relief on the basis that it was now in the transition phase for uplifting the product to Antigua. And on that basis, performance is sought in relation to the closing of Avenza and the transition to the new loading port. Now, that is followed by subsequent correspondence, my lords, in which the appellant made it clear that Antigua was in fact its new source of supply and its new loading port. Now, it also has to be borne in mind, my lord, that even though the appellant sought to engage the respondent on the issue of price, there was never any suggestion that the new loading port in Antigua was temporary and that a continued supply was contingent upon a revision in the price regime. As a matter of fact, my lords, the learned trial judge categorically rejected the appellant's evidence to the effect that there had been oral communications between the parties in which the appellant indicated that continued supply was contingent upon their being able to reach an agreement in terms of a renegotiation of the price. Going back to that letter of February 2, my lords, seeking performance relief on the basis indicated there. The respondent says, we are now in transition phase to Antigua for the uplifting of the product. This relief is in relation to the closing of Avenza and St. Croix and transition to a new loading port in Antigua. We say, my lords, that this letter makes it clear that the appellant was at this time actually transitioning from Hovensa to St. Croix as its base of supply. I'm sorry, from Hovensa in St. Croix to Antigua as a base of supply. The new base of supply being Antigua, whilst continuing to perform the contract. So it was continuing to perform the contract from this base. And so, my lords, it is seeking performance relief for the shortfall of fuel, which was associated with the making of that transition. There's still no mention up to this point, my lord, of any interest in renegotiating price as a means of making this continued supply of fuel to the appellant viable with a view to minimizing damage. Again, my lord, bearing in mind clause 10.3, and no suggestion up to this point, my lord, that the Antigua supply was merely temporary, pending discussions between the parties about price. Nor, my lords, significantly, was there any follow-up on its request made in its preceding letter of January 28, which I took your lordships to, for a meeting to discuss the contract and the implications of the closure. To the contrary, my lord, we say that this letter clearly shows that it had made it clear, the appellant was making it clear in this letter that it had moved on from Hovensa and was in the process of transitioning to its new loading port, a new base for supply under the contract. The evidence goes on to show, my lords, that then having switched its operation from Hovensa to Antigua, it sought performance relief again on February 14. On February 13, for a shortfall in supply owing to delays from what it described as our new port. That letter your lordships will find at page 939 of the bundle. And what it says, I note your letter of even date, etc., etc. In the second paragraph of the letter, it goes on to say, in this instance, with regard to this letter, I can assure you that the delay is related to short storage and berthing, since our new port has one berth and thus impacts the timing and scheduling. So it is clear from this that Hovensa is no longer a port of supply, a source of supply, a base of supply, or facility of supply. They have now completely transitioned to their new port. Hence, it is described here as our new port. And this is clear from the way in which it is here described. This letter, my lords, then says nothing also about seeking to negotiate a price increase as a means of maintaining the viability of the contract. The fact, we say, my lords, reading this evidence, that by this time it had fully transitioned to a new port of supply to continue performing the contract, rather than exercise its right to permanently suspend supply on the basis of the Hovensa closure, is also underscored by that description as our new port. Antigua, we say, it is clear from this, being communicated to the respondent, was its new source of supply, and Hovensa was no longer a source of supply or storage. This, my lords, was confirmed by the appellant's own witness, Mr. Esposito, in his evidence, acknowledges that. And my lord, if I can make good that point by directing you to page 590 of the bundle.
Yes.
591, that should be, my lords,
Yes.
of the bundle. And so as to do justice to my reference, I will begin at page 590. Well, actually, there was an exchange with Mr. Esposito about the pronunciation of his name, but we won't be detained by that. But beginning
Please not.
590 at line 17, there's a question. Page 590, my lords, line 17. Because Delta did not succeed in securing an increase in price, it took the step of terminating the agreement under the pretext that the Hovensa closure was the reason. That was the suggestion to him. He says, I disagree with that statement completely. Then he's then going on to the issue at hand. At line 3 on the next page, my lord, it is put to him in the context of the fact that this purported notice to terminate came as late as June 1. It is put to him so that by June 1st, sir, Hovensa was in fact no longer a source of supply under the contract. He says by February. By February, it was no longer a source of supply of storage. Right. So that makes good our point that by February, on the appellant's own evidence, Hovensa was no longer a source of supply under the contract. It had completely fallen away. And indeed, so that a fortiori, by the 1st of June, when it was seeking to terminate on the basis of that closure, it was not entitled to do so because it was no longer a source of supply. There is also evidence, my lords, that the appellant made a clear commercial decision not to terminate the contract, but instead to seek an alternative source of supply from which to continue to fulfill its obligations under it. We have referred, my lords, at various passages in our case. I won't take your lordships through all of them because time will not permit of that. For the moment, my lord, I will simply direct your lordship to Mr. Esposito's testimony at page 590. I'm sorry, my lords. Rather to the testimony at page 517. My lord, from line 7 onwards. At line 7 of page 519, Mr. Sylvester is being cross-examined. You knew that the circumstances would have given you an immediate right to terminate the agreement, correct? Because if your source of supply is going to be terminated, you had a right to terminate the contract on that basis, based on the performance relief clause, correct? Question, or rather his answer, yes, but there was other clause in the contract, but you didn't want to terminate. You didn't want to terminate the contract, did you? And he goes, and we had a responsibility, the contract to supply. You didn't want to terminate the contract. Commercial-wise, it would make no sense for the contract to continue. Once. And I said, this is my question, Mr. Sylvester. You did not wish to terminate the contract. It is a simple yes or no. And he says, no. Then he goes on, and so in fact, you opted not to terminate the contract, but to source a new source of supply, namely Antigua. Antigua was an interim measure for us. I didn't ask you anything about interim. We will get to that in due course. You chose, rather than to exercise Delta's right to terminate, you chose to source out a new source of supply in Antigua, correct? He says Antigua became our temporary source. Mr. Sylvester, please, and then the judge intervenes because he's not answering the specific question. And finally, he says yes. Now, the important significance of that evidence is that it is an admission that they had made a conscious commercial decision to continue to perform the contract from a new source of supply. Now, it is true that he keeps interjecting here that Antigua was supposed to be temporary. But, my lords, the learned trial judge categorically, having examined all the evidence, rejected the appellant's assertion that there was discussion between the parties in which the appellant made it clear to the respondent that the supply from Antigua was simply temporary. They say pending discussions in relation to price. The learned trial judge did not accept that evidence. And the evidence has to be, and the issues have to be assessed, have to be analyzed on the basis of the evidence which the learned trial judge accepted. And the learned trial judge's rejection of the evidence of the oral testimony about Antigua being expressed to the respondent as temporary is to be found at tab, I'm sorry, my lords, it's to be found at paragraph 83 of the learned trial judge's decision. And that your lordship will find at tab 326. Now this paragraph does not stand on its own, but arises in the context of the learned judge's analysis of all the correspondence. Yes, my lords.
Sorry, Lord Lincoln, yes.
Was it your client's case that the request for a price increase was simply a request for a favour? That Delta was saying, oh, well, we're going to continue supplying you from Antigua for the rest of the contract, come what may. But if you're very kind, you'll give us a price increase for that. Was that seriously suggested to be the gist of the discussions?
Well, my lords, it could be put in that way because we are saying, my lord, that the decision was we are going to continue to supply.
And that's what they said to your clients, was it?
Yes, my lords, because
we're supplying you anyway, but please give us a price increase just because out of generosity.
Well, not out of generosity, but we would like you to make some accommodation, bearing in mind that this is commercially difficult for us. But yes, my lords, that is precisely what happened. They agreed to continue to supply, agreed to continue to perform the contract. But in a sense, they wanted to have their cake and eat it. They wanted to affirm and continue to perform the contract, but they were hoping to get a price increase. In fact, they actually say so in their evidence. And when they were seeking to get a price increase, they had already made that decision and communicated it to the respondent. So I was taking you, my lords, to paragraph 83, where the respondent, where the learned trial judge speaks about that oral testimony. The learned trial judge says, further upon this court making its own independent assessment of the correspondence that passed between the parties, whether it was for performance, release, or otherwise, and despite the belated and unsubstantiated, and despite the belated and unsubstantiated effort of the defendant's witnesses to seek to introduce oral communications in which it is alleged that the position of the defendant was always to keep their options open, this court finds that the defendant's behavior squarely falls within the parameters of the waiver by election. Now, the learned trial judge was criticized by the appellants because of the way in which she characterized that testimony by the appellant. But the essence of the judge's pronouncement here is that she did not accept, at the end of the day, having scrutinized the evidence, she did not accept their version of events, their story, their oral testimony, that during the course of oral discussions, they had made it clear that Antigua was only going to be temporary. That simply was not the case. It is also important to bear in mind, my lords, that even though the appellants continue to maintain that the claim that Antigua was a temporary source of supply, there is actually an admission on their part in their evidence, which belies the notion or the assertion that they had made it clear to the respondents that Antigua would be a temporary supply. In fact, my lords, Mr. Sylvester, in cross-examination, admitted that no such communication was made to the respondent that Antigua was a temporary source. So even if they had internally made such a decision, it was never communicated to the respondent. And it is what was communicated which was important, because it was their conduct, whether by representation or otherwise, which was important. If your lordship looks at the transcript of evidence at page 519, we will make good that submission. But my lords, before I take you to page, I should perhaps, well, let's see, page 519. Yes, my lords, we begin at page 519. Page 519, my lord, at lines, beginning at line 16, it is suggested to Mr. Sylvester. So I'm suggesting to you, therefore, that rather than exercising your right to terminate the contract when you got the Hovensa notice, you took a conscious decision instead to find a new source of supply in Antigua so that you could continue to supply fuel to the corporation, correct? He asked for the question to be repeated. The question was repeated. And then he started a response. Antigua was not. Question, I didn't ask you that. You decided to seek a new source of supply in Antigua, didn't you? He asked again that the question be repeated. He has a difficulty with it. You decided to seek a new source of supply in Antigua so that you could continue to source supply, so that you could continue to source fuel to supply the electricity corporation and others of your customers who would be affected by the Hovensa closure. He said temporarily while we negotiated. Question, when you decided to seek a new source of supply, you made this decision not to terminate the agreement, but to find an alternative source of supply. Did you notify the corporation when you made that decision that you were deciding to continue to supply them temporarily? No. So that was a decision known only to you and Delta. It is put to him. So even if they had made a decision internally, if it wasn't communicated, all that the respondent had to go on was what was actually communicated. And what was actually
all of this argument, Mr. Dennis, predicated on the proposition that Delta had a single choice. Either it terminate the contract or it elected to continue to supply. I've on a number of occasions tried to point out to you that a different argument is available, namely that it wasn't a stark choice between those two alternatives. Delta could have decided that it would continue to supply temporarily while it preserved its right to performance suspension if the efforts that it made proved unavailing or uneconomical. Why is it that you say that the choice was as stark as you portray it to be?
Well, my lords, I acknowledge your lordship's point that it could have sought to perform temporarily while it negotiated a price increase. But what we say, my lord, is that the evidence suggests otherwise. The evidence does not suggest that it took the decision to continue to perform only temporarily pending a price increase. And I have a discussion of a price increase. And I have taken your lordships to the evidence.
If you look at page 520 at line 15, the answer given was temporarily while we negotiated.
Yes, my lord, but again, I take your lordship to the learned trial judge's analysis of the evidence, and the learned trial judge categorically rejected their evidence and their assertion that all of this was simply temporary. They were asserting that. Their assertion that it is temporary is one thing. That was their version of events. The respondent's version of events was that this was not temporary, that this was a permanent transition to a new source from which this decided to continue to perform the contract. So the learned trial judge had two competing versions of events as to whether this was in fact temporary or in fact it was permanent.
Well, on what basis did she reject the assertion that this was temporary while they negotiated?
She rejected the assertion, my lord. She rejected the assertion, my lord, because as I've shown you, my lords, even if in Delta's mind this was temporary, it was never communicated to the respondent. And the respondent could only rely on what was communicated to it. And there was no communication to the respondent.
So it was on the basis of a failure of communication.
It was well, that was one basis, my lords. It was because, my lords, at the end of the day, whatever you have in your mind, if that is not communicated, because bearing in mind that the corporation needed to know where it stood. Right. And in order for it to know where it stood, it had to rely on what was said and on the conduct of the appellant. If the appellant keeps saying in its correspondence, we have transitioned to a new loading port. This is our new loading port. This is the base from which we are making supplies. Hovensa having closed and we having sourced this new source of supply.
What if Delta says to itself, what if Delta internally says to itself, look, we're not going to make an election here to continue with this contract. We're going to see if we can get alternative supply, and if we can't, then we'll have resort to clause 10. Do you say that it's not open to Delta to take that position unless it communicates it to your client?
No, my lords, I'm not saying that. What I am saying that if it does not communicate that decision to the respondent, and at the same time, in its actual communication to the respondent, says otherwise, says the complete opposite, then all that the respondent has to rely upon is what is actually communicated. Because in order for it to know where it stood, it would need to know what Delta's decision was. So if Delta makes a decision...
The consequence of that argument, as it seems to me, is that even if Delta decided consciously not to make an election, it was forced into the position that it had in effect made an election because it didn't communicate with your client. Is that what you're saying?
Because it didn't communicate, my lord, that is one part, and also because in the communication which it actually made, it said that it actually said that it was not going to terminate. So it's two things, my lord.
Yes, but termination.
If they made an internal decision, it wasn't communicated.
Clause 10 is not confined to termination of the contract. It's concerned with the suspension of performance, which embraces a far wider spectrum than termination.
Well, my lord,
in any event, I think we've probably exhausted this topic. Unless there's something else that you want to say about it, I think we should move on.
No, my lord. I would simply end by saying, my lord, that there were two things which we are relying on. One is the fact that that decision was never communicated, and two, that in the correspondence where it actually did communicate, it was saying the very opposite. And that is all that the respondent had to rely upon, because it is the conduct and what the appellant said that it had to be guided by in order to know where it stood.
Right. Thank you very much. Well, let's move on then.
Going on, my lords, in relation to the evidence, we say that it was only after the transition to Antigua, by which time we say an election had clearly been made, that the appellant sought to renegotiate the price on the basis that it was unprofitable to continue. And that, my lord, is the letter of February 19, 2015. And that, your lordships will find at EB 943. I'm sorry, my lords, I seem to have got my reference.
All right, don't worry.
The letter of the EB 943, my lords. So we say that it was at this stage. This is after the transition to Antigua and its communication of that transition to Antigua, by which time an election had clearly been made and communicated, only then did the appellant seek to renegotiate price on the basis that it was unprofitable to continue. And in this letter, in the third paragraph, Delta writes, Delta Petroleum has sought to secure loading and supply in Antigua. In the process of making the switch to our new loading point, we have incurred additional charges for supply and freight. This amounts to 3.0 cents per gallon. These higher costs are real and make the contract unprofitable for us to continue to supply unless relief is achieved. We would be most grateful if the BVI Electricity Corporation could accommodate this increase in the contract premium relative to the Platts index. So going back to a question which my Lord Leggett raised earlier, this is the very first time that the notion of a price increase to be negotiated because of the unprofitability of the continuing source of supply was being raised. Is being raised here.
It's not the first time. It's not the first time, Mr. Dennis, because there was the finding of the meeting on the 6th.
Actually, my lords, I stand corrected on that. I stand corrected on that. That was the meeting of February 6th. I stand corrected on that, my lords.
And there's a reference, I think, to our initial conversation in the fourth
Yes,
paragraph.
my lords. I do stand corrected. I do stand corrected on that. But again, my lord, the point is that this meeting of February 6th and the whole notion of a price increase was coming after the fact. That is, after it had clearly, by the previous correspondence, communicated what in effect was its decision to continue to supply from Antigua as a permanent source. And then, my lord, there's some other correspondence, the details of which I will not go into, which in which the corporation, through its general manager, refused to entertain the notion of a price increase. And ultimately, because Delta was unsuccessful in persuading the corporation to entertain that price increase, it ultimately took steps to terminate, well, to permanently withhold supplies, thereby effectively bringing the contract to an end. So there was a letter of March 4, 2015 at EB 945, where the respondent replied to this February 19 letter, indicating that the costs should balance out because there had been a fall in the cost of fuel, and he refused to entertain a number of the suggested concessions which the appellant was belatedly seeking to make. There's a March 9 letter at EB 947 rather, where the respondent replied to a previous letter of the appellant, repeating his assertion. Where the appellant repeated its assertion that it could not continue to supply at no profit. So it was here seeking to pursue this price increase issue, which it had raised for the first time at a time when it had already, we say, made its election and communicated it. On March 12, 2015, and this is the letter at EB 949, it sought performance relief on the basis of the delay in Antigua. So even at this stage, it was continuing to seek performance relief on the basis of the delay in Antigua. Nothing to do with Hovensa at this point, which, as we say, was a spent issue. And then, my lords, for the very first time, in his letter of May 18 of 2015, which your lordships will find at page 987, the appellant stated for the very first time that the continued supply was linked to a minimum contract price. And if I could take your lordships to that, 987.
Yes.
The letter on 987, my lords, the third paragraph, the salient portion, the middle of that bullet point paragraph, the only reason we continue to supply BVI-EC this year is because you agree that the negotiations would take place to allow increased costs to be passed on as an alternative to an outright termination of the refined petroleum supply. That, of course, was rejected or denied by the respondent. Then in the next bullet point, the last sentence, he says, continued BVI-EC supply from Antigua was always linked to a minimum contract price adjustment plus other possible incentives. This is the very first time when there was any suggestion that continued performance would be linked to an increase in price. Then ultimately, my lord, we have the letter of June 1, in which the appellant purported to terminate the contract or to permanently withhold supply. So that in a nutshell, my lord, was the evidence which was before the learned trial judge. And despite the criticisms which have been leveled at the learned trial judge, we say, my lords, the learned trial judge cannot be faulted on its analysis, on her analysis. My learned complains against the learned trial judge's findings, but it seems to us, my lord, that in essence, what this board is being asked to do is to substitute its own view of the evidence which the learned trial judge analyzed and accepted evidence which she thought was reliable and rejected evidence which she thought was not reliable, and came to a factual finding on the basis of which she applied the principles of law. And this, my lord, takes us squarely into the realm of Watt and Thomas. And unless it can be shown that the learned trial judge's findings and the endorsement of that by the Court of Appeal were wholly unsustainable, palpably wrong, even perverse, there is no room for an appellate court or board to substitute its view of the evidence for that of the trial judge, who had the benefit of assessing the witnesses and assessing the material which was before her. And my lord, if I could just take you briefly to the learned trial judge's analysis. And in particular, paragraphs 60 onwards.
Can you give us a page number, please?
This is at 320, my lords.
Thank you.
So, having set out the law in the preceding pages 318 to 319, the judge goes through the evidence in detail, She deals with the fact that having received notice of the Hovensa closure, that was not communicated. I won't dwell on that because I made my submissions in relation to the significance of that already. She goes on to consider the letter of the 27th of January, in which the appellant spoke about the notice being given by Hovensa for them to move by the end of January 2015. She then adverts to the fact that the appellant then belatedly sent a letter on the 28th of June alerting the respondent to that notice and inviting her to discuss the contract and its implications. And she says subsequently that that evidence leads to an unmistakable conclusion that based on the Hovensa closure, the further notification of same, at that point, at the very latest, defendant's right arose to seek permanent performance relief. So at that stage, at least, it could either seek permanent performance relief or continue to perform the contract. And yes, my lords, it was open to it at that stage to begin to engage the respondent on issues of price increase to make the contract more viable. But as I have shown in the evidence, that is not, in fact, what happened. It did not do that. And then, my lords, at paragraph 64, the judge makes the point that did not happen. It did not seek to invoke that right. What in fact appears to have happened is that the defendant sought to explore an alternative avenue. So the learned trial judge adverts to this fact. These subsequent events are what is the very essence of the contention between the parties, and whether what thereafter transpired could have amounted to a waiver. So the judge had squarely in mind how she had to deal with this evidence. And she goes on in the next paragraph to deal with the January 28 letter. And observe that in this letter, the defendant made 3 distinct references with regards to Antigua. The transition to Antigua as the loading port, no loading on Antigua, and the transition to the new loading port. So the judge was bearing in mind what the effect of that communication, what the import of that communication was. She goes on at paragraph 67. If that was not enough, by letter dated 30th February, the defendant's regional general manager, Mr. Sylvester, tells the claimant in his application performance relief, I can assure you that the delay is related to the short storage and berthing, since our new port has 1 berth. And she obviously placed some significance on the fact that it was described by the respondent as our new berthing port. There was a subsequent letter in which Antigua was also so described as our new port. The learned trial judge was criticized for it was submitted her placing undue weight on the use of the nomenclature, so to speak, our new port. The judge placed significance on that, my lords, because the use of the expression our new port clearly signified that this was now their new port of supply, no longer Hovensa. That had fallen away. And so they couldn't subsequently be seeking performance relief on the basis of the closure of a port when that was no longer in issue. Now, it is being submitted that the significance attached to the description of a new loading port was inappropriate. But in the context of the evidence, it was not. Because, my lords, Mr. Sylvester himself, in his own evidence, made the distinction when taken to the correspondence in which reference was made by Delta to a new loading port. He took issue with our suggesting that Antigua was their new port of supply, because he said, oh, it says a new loading port. It doesn't say our new loading port. And when asked, what is the difference between a new loading port and our new loading port? His answer was, if it was our loading port, it would mean it is permanent. If it is a loading
Well, thank you very much. We'll take a 5-minute break now. You have 24 minutes left, Mr. Dennis. So we'll resume again in 5 minutes' time. Thank you. Now, Mr. Dennis.
Yes, my lords, I was about to take your lordships to the evidence of Mr. Sylvester, in which he himself made the distinction between a new loading port and our new loading port and the significance of that. If your lordships could turn up pages 524 to 528 of the bundle, and that is a transcript of the proceedings in the court below. And I will take your lordships first to page 524. And just to put the cross-examination in context, this is in the context of the February 2nd letter, in which the respondent speaks about Antigua, the new loading port. And so beginning at line 14, question, you said, beginning at line 12, or rather, my lords, before that, let us begin at line 7. So a transition which would refer to in the penultimate paragraph. This is the penultimate paragraph of the June, of the February 2 letter. We are now in transition phase to Antigua for uplifting product. In the context, my lords, of our case that they were transitioning to a new port. You were transitioning from where? Answer, St. Claude. Question, precisely. Which was your original place of or source of supply? Answer, you said to a new. I didn't say to our new loading point. It is a loading point. We are now in transition phase to Antigua for the lifting of product. Answer, well, I didn't say here that this was our new. As a company, this is our new loading point. I said it is a loading point. If your lordship then turns to page 529 and pay at line 6, he's asked, why is the use of the words a new loading port as opposed to our new loading port? Why did you point out that distinction which was not invited? And why do you consider it so significant? Answer, because it was our new loading port, we would have had a contract with that company. No, that is not what I am asking you. Answer, because I can't use the word our, because it's temporary. The clear implication of that being that if it is described as our new loading port, that would be implying or suggesting that it's permanent. Then I took him to the subsequent letters, and there are 2 of them following the February 2 letter. I took him to the letter of February 13, in which he describes Antigua as our new loading port.
Well, I'm sure, Mr. Dennis, the outcome of this case is not going to depend on whether it's a loading port or our loading port.
Not at all, my lords, but the significance of this evidence and the point of it is that this is a clear indication that, contrary to the appellant's continuing assertion that Antigua was a temporary loading port and that was communicated to the respondent, their own evidence belies that, because it is clear from this evidence that it was a permanent new loading port. And if it was a permanent new loading port, it meant that Hovensa was no longer an issue. So whilst they could see...
I mean, that's not in dispute. Hovensa isn't a possibility any longer. I mean,
precisely, my lords.
Hovensa was history, so to speak.
Precisely, my lords.
I'm not quite sure what point is being made about whether it's our loading port or a loading port. But in any event, I think we've probably exhausted that topic. So why don't we move on to something else?
Very well, my lords. And so, my lords, just to wrap that up, I say the learned trial judge had the benefit of that evidence. And so, my lords, the statement which he makes at paragraph 83 needs to be seen in that context, because that it was clearly showing that the learned trial judge was not accepting the appellant's assertion that Antigua was always a temporary source of supply. To wrap up, my lords, I will just deal with a few brief points which arose from my learned friend's submissions yesterday.
Yes, thank you.
But before that, my lords, I would simply say, in connection with this aspect of the matter, that the learned trial judge clearly considered the evidence before her. She clearly applied the principles of the law of waiver. She clearly acknowledged that the respondent was in a position where it would have needed to know where it stood. And the fact, my lords, that the trial judge's ultimate findings of fact are not findings with which some other tribunal looking at it would necessarily have arrived at. The issue is not, that is not the issue. The issue is whether, looking at the evidence in its totality, the finding was so completely divorced from the reality of the evidence that she could not possibly have reasonably come to that conclusion, not whether some other tribunal would have come to a different conclusion. And that, again, as I said, my lords, is squarely within the realm of Watt and Thomas. And this court ought not to disturb her findings, or indeed the findings of the Court of Appeal endorsing this. So we say, my lords, that for all of those reasons, by June 1st, if Hovensa was pent, it was no longer an issue, then the appellant could not properly rely upon it. Now, my learned friend submitted to your lordships that because there was no limit on the exercise of the rights of the respondent in clause 10.3, in clause 10.2, to seek performance relief, having regard to the fact that it had an absolute discretion. It was a continuing right, and it could exercise it at any time. In other words, the right was limitless. We say, my Lord, that that could not be the case. If my learned friend's argument were correct, it would mean that the respondent would be, it would mean that the appellant would be entitled ad infinitum into the future to be able to rely on the Hovensa closure as a basis for terminating the contract. 3 years, 4 years after the Hovensa closure, if you took their argument to its logical conclusion, they would be able to invoke Hovensa as a basis for seeking performance relief. We say, my Lord, that that cannot possibly be. The right which the appellant had in relation to clause 10.3, we say was not limitless, as the appellant seeks to suggest. Far from that being the case, my lords, we say a proper construction of that clause did not confer any such limitless power. On the appellant. 716. I crave your indulgence, my lords. Rather, my lords, we say my lords, and this is the simple point, that the right to terminate pursuant to clause 10.3 was absolute only to the extent that on the happening of a specified event, in this case, the closure of Hovensa, the appellant had the right, in its sole discretion, to do the things contemplated by that clause, including termination, that is permanently withholding supply, in its sole discretion to do that. But if, as happened in this case, it elected not to exercise that right and instead affirm the contract as it did by sourcing a new source of supply, clause 10 would not in those circumstances give it an absolute right to later resile from that election, however long after the specified event, and invoke that event as a basis for terminating the contract. That could not be, my lords, we submit, because if that argument were to be accepted, it would mean that the appellant would be at liberty indefinitely to use the Hovensa closure as a basis for terminating the contract. The respondent in those circumstances would never know where it stood. This, my lords, we say, would be a clearly untenable position. So the learned, the criticism of the learned trial judge for taking that position that by June 1, they could no longer rely on it is not a criticism which can reasonably be sustained. One short point, my lords, on clause 17. I believe my learned friend conceded that if your lordships are with us on of election and that an election was actually made on the facts and as a matter of law, then clause 17, which your lordships will recall is the forbearance clause, that cannot protect the appellant against liability. It could not avail the appellant if your lordships find that there was an election, because as the authority, as Cavendish shows, you have either made an election or you have not made it. And once you have made it, it is final. And a general forbearance clause saying if you forbear on any of your rights, that will not result in your losing it. It clearly would not apply where a conscious commercial decision, which we say was happened in this case, and which indicated an election. Once that election was made, and your lordship finds that there was in fact an election and a communication of it, the appellant would be bound by it and could not resile from it. And so clause 17 would clearly not in those circumstances absolve him. My learned friend complained that the learned trial judge took the letter of February 7 as clear and unequivocal representation of election. We say that criticism of the learned trial judge is unfair, because the learned trial judge did not just rely on the letter of February 2nd. The learned trial judge relied on the chain of correspondence, beginning with the Hovenza closure and what she made of it, and ultimately concluded that there was an election. So it wasn't purely reliance on the February 2 letter. And I pause here, my lord, to make the point that the February 6 letter, the February 6 meeting, which was concerned with a discussion of price. And that meeting, my lord, took place after this February 2 letter, in which the appellant was making it clear that it had transitioned to their new loading port in Antigua, which Mr. Sylvester confirmed was permanent.
Yes, Lord Sales.
I'm afraid I'm not hearing you, my lord.
Forgive me, my fault. It was just to point out that the judge didn't find that the election occurred by the 2nd of February letter. She reviewed the correspondence through February and found in paragraph 69 that the election had occurred by the end of February. Help us with that.
Yes, my lord. So it would have been. I'll go to that aspect of the judge. Could your lordship repeat the paragraph to which your lordship is referring?
Yes, paragraph 69, where the judge makes a finding that there had been an election, and says,
69.
Yes, it says that it was by the end of February.
Right, 69. With your lordship's indulgence. Right. So, having reviewed the correspondence, the learned trial judge says at 69. So, what is clear to this court is that by the end of February 2015, on no less than 3 occasions, the defendant categorically referred to Antigua as being their new loading point, etc., etc., etc. And she quotes from the correspondence. However, even by mentioning these higher costs, etc., well, that section is not really relevant. So, my lords, the learned trial judge hasn't indicated in terms of a finite point in time when the election occurred. she hasn't actually said so. However, my lords, what she says is that certainly by the end of February, in other words, that would have been the very latest. The end of February would have been the very latest point at which, based on the correspondence which she reviewed, they could be said to have made an election. But she's not saying here that the election was made at the end of February. She's just saying that whenever it was made, certainly by the end of February, it would have been clearly made and communicated. And I do not believe, my lord, that that diminishes the learned trial judge's analysis, because after all, she was dealing with a chain of correspondence. We would say, my lord, that certainly by the 2nd of February, when it communicated its transition to its new port in Antigua and advised us of that, that certainly the election would have been made by then. The learned trial judge didn't use that as the marking point when the election was made, but she was simply saying that whatever point it was, by the end of February, it had clearly been made. And then, my lords, I will just deal with a few brief other points. My learned friend jettisoned the ground of appeal in relation to liquidated damages or penalty. However, my lords, on the liquidated damages and the awards which were made, my learned friend says that if they were entitled to rely on clause 10.3 for permanent performance relief, they would have been entitled, they would not have been liable to liquidated damages, and so that should not have been granted. My simple answer to that, my lords, is that if on the other hand, your lordship accept our case, that the appellant was no longer entitled to rely on the Hovensa closure in June to seek performance relief, then it would mean that they would not have fulfilled their obligations under the contract as they were supposed to. And the liquidated damages clause would kick in. In other words, my lord, if your lordship's fine for us on the election point, then it would stand to reason that we would have to prevail and be entitled to liquidated damages pursuant to the liquidated damages clause. And finally, secondly, my lord, the second set of liquidated damages against which they complained were those 3 sets of liquidated damages which they argued the learned judge should have considered to have fallen within the 3 grace periods to which they were entitled. But as your lordships pointed out, an entitlement to those 3 grace periods was contingent upon the appellant satisfying the requirements to benefit from that, namely explaining the reason and giving and providing other information in order to allow them to do so. In other words, there were preconditions. My learned friend candidly admitted that there is no evidence that those conditions were ever satisfied. And in those circumstances, my lord, both the High Court and the Court of Appeal would have been right to say liquidated damages were indeed payable for those periods when the fuel supply fell below the required level. Finally, my lords, on the counterclaim we say is entirely misconceived, because if your lordships turn up the defense and counterclaim at tab 193, at page 193 of the bundle, it is clear when one looks at the closing paragraphs at that defense and counterclaim that the counterclaim is pitched on the basis that the appellant suffered damage as a result of having to continue to provide supply at what we deduce, they're saying, at a loss as a result of having to supply after the injunction. But that, my lords, would appropriately be a matter for an inquiry as to damages, having regard to the undertaking as to damages, which was given by the respondent as a basis for getting that interim injunction, forcing it to perform the contract. In other words, specific performance. It is not, therefore, an appropriate subject for a counterclaim. And so, even if your lordship finds against us, that counterclaim should be dismissed. My lord.
Can you just tell me the history in terms of what cross undertakings and damages were given? Was there an interim injunction and then a final order for specific performance?
The proceedings actually began, my lord, with an application by the respondent after the appellant served the notice of June 1, in which it purported to, in effect, terminate the contract. The respondent applied for an interim injunction to require it to continue to perform and to supply us with fuel at the contract price. The learned trial judge in those proceedings granted the application for an injunction. And your lordship will see an order at page 141 of the trial bundle, in which the court ordered that pending the hearing and determination of the claim or until further order, the defendant was to continue to supply fuel to the respondent. And in the preamble to that order, my lords, there's a recital indicating the undertaking as to damages, so that if your lordship looks at the first page of that order, on that same page 141, it reads, and upon the applicant.
Well, I can see the cross undertaking, yes.
Yes, my lord, to abide by any order, the court may make us damages, etc. Yes.
But then, when you got the order for specific performance, was there any undertaking in damages given then or later that if Delta succeeded on appeal and it turned out the order for specific performance was wrongly made, then the respondent would gave an undertaking to be responsible for damages caused by that?
Well, the terms of the order, it says pending the hearing and determination of the claim.
I know this order does. So I now ask you to move on to when you successfully got an order for specific performance. And I'm asking whether either then or in the Court of Appeal, there was any undertaking given or requested that in the event that the appeal succeeded and so specific performance was wrongly granted,
my lord,
there would be responsibility for damages caused.
I don't believe, my lords, there was any further undertaking.
Right. Thank you.
We're double checking that, my lord, and if your lordship pleases, I could let your lordship have the benefit of that that research which we are doing even as I speak, my lords. But I do not believe that there was any further undertaking. Once the hearing was concluded and there was a decision in our favor, I do not believe there was any further undertaking, nor do I believe there was any in the Court of Appeal. That's my recollection, my lord. Yeah. But certainly, any loss or damage in that interim would be the appropriate subject of an inquiry as to damages. Certainly, up to the hearing and determination of the High Court claim. So for all those reasons, my
Thank you,
lord,
Mr. Dennis.
we submit the appeal should be dismissed.
Ms. Lang, wish to follow?
No, my
Dennis?
lords. No, my lords.
Thank you. Right. Mr. Guthrie.
My lord, there are only two areas on which we would want to reply. The first is I would like to respond to certain of the questions asked by your lordships in relation to the construction of clause 10. And we're also conscious that some questions as to damages have, so to speak, been left in the air. I'd be grateful if your lordships would hear Ms. Patel on the issues relating to damages. My lords, the questions asked about clause 10, it was my Lord Legate who first asked me whether I agreed that clause 10 did not confer a right to terminate the agreement, only a right to withhold performance indefinitely. And indeed, obviously it confers a number of lesser options as well. I respectfully agree with that proposition. It's apparent from the terms of clause 10 itself, which don't refer to a right to terminate the agreement. Clause 10, subclause 2 might have said something to the effect that the seller shall be at liberty to terminate the agreement, or the seller shall not be bound by the agreement. But it doesn't say that. And my lords, the position is reinforced by the terms of clause 12 of the agreement, which I don't think we've expressly looked at before. It's on page 892.
Yes.
It's a contractual termination clause and is expressly made subject to the right of the buyer in its sole discretion to terminate this agreement forthwith under any of the provisions of this agreement. And there is such a right conferred on the buyer by, for example, clause 3.7, which is at page 879 to 80 of the agreement. I'm sorry, of the bundle, and clause 5.4 of the agreement, which is at page 883. But there is no mention of the seller's right in its sole discretion to terminate the agreement, as one might expect of clause 10, or one might expect, sorry, if clause 10 conferred a right on the seller to terminate the agreement. The position is also reinforced, my lords, by the fact that the agreement makes no attempt to exclude either party's common law right to terminate it. Clause 12 does not purport to provide the only mechanism by which the agreement may be terminated following a breach. My Lord Hamlin then asked whether, if clause 10 only conferred a right to withhold performance indefinitely, performance could be resumed again when circumstances changed. And I think I replied by saying that since the relevant circumstance here was a Havensa failure, specified by clause 10.1d, it was difficult to see how that circumstance might change. But in fact, the clause refers to any supplier, not just Havensa. The point was developed, if and put it like that, by my Lord Sales, who posed the possibility of the price of an alternative supply of fuel to Havensa falling, so as to become economical within the original parameters of the agreement. My lords, we would accept that if performance had been validly withheld indefinitely, pursuant to clause 10 following a Havensa failure, and the agreement had not in the interim been terminated by either party, then it would be possible for the appellant to resume performance in the manner contemplated.
Yes, Lord Briggs.
Yeah. I'm sorry, you're muted.
I think you You need to unmute.
It's all right. I'm unmuted, I think, now.
Yeah.
It's an odd result commercially, isn't it, Mr. Guthrie? Because suppose that Delta said it was going to suspend performance indefinitely. It's clear from clause 10 that that then frees the respondent to meet the shortfall by contracting for alternative supplies. But it would be quite tough if you had to contract on a sort of spot basis for alternative supplies rather than on a time contract in which there was some inevitable duration of that alternative supply. It would be strange, for example, if this is a 4-year contract. So say they, at the end of year 1, Delta says, well, we're going to suspend supply indefinitely. Now, one would expect in those circumstances, the buyer could contract on a term contract for the remaining 3 years from somebody else, but it's not what the end of clause 10 quite provides in terms.
In reality, my
It
lord,
only deals with providing other supplies to meet the shortfall.
in reality, my lord, one would expect the contract to be terminated in the event of a, so to speak, open-ended
Yes.
operation of it.
Yes. You mean by mutual consent?
Yes.
Yes. That may, I mean, I suppose that may be the answer. Anyway, thank you.
My lord, Lord Legate asked Mr. Dennis whether it was possible for the appellant to keep the agreement on foot following a events of failure, but then subsequently, for example, in June 2015, to say that it wanted to suspend it for 2 years as the alternative supply of fuel was more expensive than it had anticipated. Now, I understood Mr. Dennis to say that the appellant could legitimately do that. And then Lord Legate pointed out in our submission correctly that that is exactly what happened in this case. The answer Mr. Dennis gave was to seek to distinguish the present case on the basis that the reason for the request for indefinite performance relief was the cost of the alternative fuel rather than the events of failure. But the reality is that the cost of the alternative fuel was only an issue because of the events of failure. So the request for indefinite performance relief was therefore still by reason of the offence of failure as per clause 10(2) of the agreement. Lord, Mr. Dennis also complained that we, so to speak, could be forced to bear the results of our election as a result of our failure to communicate. There was an exchange on that basis earlier on today. My Lord Sales referred to the judge's finding that the election had taken place by the end of February. Lords, I would simply go back, if I may, to the letter dated the 19th of February at page 943, which I know we've looked at several times, and I don't propose to take you through it again, but the fact of the matter is that that letter expressly communicated the appellant's position and concluded, as your lordships will recall, with the proposition that unless something were done before the end of March, the party should prepare for the alternatives. But it was an express reference to the need to increase the price if the contract would continue. Well, the analysis we say of clause 10, which I've summarized, demonstrates why waiver by election was in this case entirely inapt as a doctrine to decide the matter. Election being the exercise of a right to choose between two inconsistent remedies, as your lordships have observed. And then in the bundle, we have not only Lord Gough's a statement to that effect, but also Lord Rick's in Cosmar Villa Holidays, which the reference is for your lordship's note. I don't propose to take you to it now. Page 1318. Of course, that was cited in the High Court judgment at paragraph 74, which is on page 323. And it was on the basis of a supposed election between two alternative and inconsistent possibilities that the judge and the Court of Appeal decided this case. But in the present case, it was not appropriate. The clause 10 did not offer two inconsistent alternatives, which the appellant was bound to choose from. It offered a number of alternatives short of and including indefinite withholding performance. And in our submission, there was nothing at all inconsistent about identifying an alternative supplier, in this case in Antigua, Shell, Antilles, and temporarily bearing the costs of continuing to supply under the agreement using that supplier, while trying to negotiate the contract to facilitate doing that on a permanent basis, and then later terminating the agreement. The right to terminate the agreement was separate from the right even to withhold performance indefinitely. The analysis of affirmation against termination was incorrect. It was possible for the appellants to adopt one of a range of options under clause 10, from continuing to supply on a temporary basis to withholding performance indefinitely, without abandoning the entirely distinct right to terminate the agreement, because none of those options was in truth inconsistent with the right to terminate. The doctrine of waiver wasn't appropriate. And in the last analysis, this was a straightforward case of a breach of contract by the respondent. Lord Leggett. I'm sorry, you're muted.
I still don't know what the breach of contract by the respondent said to have been.
The refusal to entertain the application for performance review.
Well, that's right.
Where is the
Shuffling
contract?
papers, which makes it very difficult to hear. I'm not sure whether it's you, Mr. Guthrie, but if you could refrain from shuffling the papers, it interferes with your. Yes. Do continue, Mr. Guthrie.
Is it an implied term, Mr. Guthrie? Because it's not in the express terms of the agreement.
Well, Lord,
the obligation is to pay the price of the fuel, which they did.
But if we were entitled to withhold performance indefinitely and they refused our entitlement to do it, that is a breach of the contract.
Which particular obligation?
Well,
clause. Which clause?
Well, it's under clause 10, is it not?
No, well, I think we may have been around this before, but I haven't been able to find it there.
Well, sure, presumably there must, at the very least, be an implied term not to unreasonably withhold consent where there's the express right to apply for it.
Lord Briggs first and then Lord Sales. Lord Briggs.
Mr. Guthrie, even if there is, unless you're submitting that the right to withhold performance is dependent under clause 10 upon getting a positive response to the request, and it doesn't look like it from reading clause 10 as a whole, what loss would be caused from a refusal to agree to permit you to do something which you were entitled to do in any event?
Could you repeat that? I'm sorry.
Yes. And unless you're submitting that the right to withhold performance in clause 10 was conditional upon getting a positive response to your request under clause 10.3, until when you simply had to continue to perform, why would a refusal or a failure to accede to your request cause you any loss if it didn't affect your entitlement to reduce your performance?
Suspend your performance.
Sorry, a moment, my lord.
Suspend, reduce, or whatever it is.
Yeah.
What we were entitled to. Well, I think we are saying, my lord, that we're entitled to get a positive response to our request to withhold performance.
Yes, but so what? Sorry, I've spoken rather quietly. You may be, but unless getting that positive response was a condition of your right to suspend or be excused from performance, I don't see how the failure to provide it caused you any loss.
In other words, Lord Briggs is saying, well, you could exercise your right to suspend performance. You didn't need for any positive reaction from the respondents at all. I mean, that was your right under the agreement.
But surely, my lord, we did, under the contract, need a positive response.
Why?
You didn't think you did. You had to be injuncted.
Otherwise, what is the purpose of clause 10.3, which requires us to make a request?
Well, on your case, if that was so, Mr. Guthrie, then you were obliged to continue performance because you didn't get a positive response.
I'm afraid I'm finding this rather difficult to follow.
Well, I think probably we've taken as far as we can. Lord Sales had a question. Lord Sales.
It was very much along the same lines. It was to explore the significance of clause 10.3 and whether it was implicit in clause 10.3 that a positive response to a request was required in order to trigger the relief from performance. I don't know if that's how the
question is yes. We think the answer to that question is yes.
Just in terms of the way the case was pleaded, as I understand it, by the appellant, at page 185, again at page 188, so page 185.
Yeah. Yes.
Paragraph 11 in the defence and counterclaim.
Yeah.
Paragraph 11, the claimant chose not to provide any additional concessions while at the same time trying to prevent the defendant from exercising its rights under the contract. As a result of this,
I'm sorry, my lord. Did you say paragraph 11?
Paragraph 11 is what I was looking at. You may have another one in mind.
On page 185.
Page 185 is the last part of it. You see that? The claimant chose not to provide any additional concessions while seeking at the same time trying to prevent the defendant from exercising its rights under the contract, and as a result, breach of its contractual obligations to grant performance relief. And then at 188.
Yes, it's 188A, I think, is it Laura is referring to, under the first line of the counterclaim. A declaration that the claimant has breached the contract by its failure to provide the defendant with performance relief.
Yes, and then the claim for damages in the sum and continuing until the claimant performs the requested performance relief at B.
Well, that is...
Mr. Guthrie, if I may say so, I think we are entitled to know clearly what you are saying gives you the right to damages in the situation that has arisen. Because, as I think my Lord Legate has pointed out and is concerned to examine. There doesn't seem to have been a cross-undertaking in damages in relation to the order for specific performance. And of course, usually if you get an injunction or an order for specific performance, what gives you your cause of action to get compensation if it shouldn't have been granted is the cross-undertaking.
Well, my lords, as I think I indicated, the issue of damages is going to be dealt with by my learned junior, Ms. Patel. One observation I might immediately make is one doesn't normally, I think, expect to find a cross-undertaking in damages attached to a final injunction. But maybe if you're...
I agree with you, but then can you help us with what happened? And it must have happened before, where there is a final injunction or an order for specific performance, and there's an appeal. The appeal is allowed, and it all emerges at that point that the injunction or order for specific performance should not have been granted. There is no cross-undertaking. One might think that there ought to be some mechanism for unwinding the situation that has been brought into existence by the court's final order. But at the moment, I'm not sure what it is.
If you'll give us a moment, as you know, it was rather difficult yesterday for Ms. Patel to follow because of the social distancing and so forth we're observing, and the fact we only have one laptop between us. But if you give us a moment, she will come and take my place to deal with the issues relating to damages.
Yes, thank you.
Thank you. Ms. Patel,
my
welcome
lords.
to the arena.
The hot seat. I will do my best to assist, my lords. I take it that there are no questions arising from the position that we've set out in relation to the damages awarded to the respondent, and I will therefore just focus on the counterclaim, which seems to be the main area where some clarification would be of assistance.
Yes.
The way that the case was pleaded, as my Lord Sales has identified, namely the breach that was said to give rise to the counterclaim, is set out in the defence at paragraphs 2K and 34. So that's pages 183. Page 183, 2K. And page 192, paragraph 34. And the way the claim is put is that the appellant said that on the 1st of June 2015, it gave notice of a request for performance relief, seeking to indefinitely suspend the supply of fuel under the agreement pursuant to clauses 10(1)(d), 2C and 3. And then at defence paragraphs 14 and 35, bundle pages 185 and 192, that it was the respondent's refusal to provide the requested performance relief, which was a breach of those clauses. See also defence paragraph 39A, bundle page 186. And to tackle the question that has been posed by my Lord Legate, amongst others, as to whether there was a requirement for the respondent to accede to a request for performance relief, the appellant's approach throughout these proceedings is that that indeed is the proper analysis of clause 10. clause 10.1, which contains the triggering causes that give rise to a right to performance relief, is stated to be expressly subject to the remaining subclauses of this clause 10. I'm on page 889 of the bundle,
Yes.
reading from the first sentence of clause 10.1. So these clauses are expressly subject to the remaining subclauses. One of those subclauses is paragraph 10.3, which contains the requirement to make a request for performance relief in writing, specifying the reason, thereby providing some transparency to the receiving party, the buyer, as to whether the request is properly made, whether one of the triggering clauses in 10.1 is properly engaged. And it's also obviously in that clause that we find the obligation to take reasonable steps to minimize delay or damages caused by foreseeable events, which, as our submissions have indicated, is a sort of overriding obligation on the party invoking performance relief that always applies. And there's also the timely notification requirement that one of my lords raised earlier this afternoon. It is correct that there is no express requirement in clause 10 on the buyer to accede to a request for performance relief. But it must be the case that clause 10.3 serves a purpose, and that purpose must only be, surely, that the reason a request has to be made is because a request has to be answered in order for the performance relief to be valid. And in our further submission, therefore, there must be an implied term to give business efficacy to the clause that any consent to a request for performance relief is not to be unreasonably withheld if, in fact, the trigger clauses in 10.1 are properly met, if clause 10.2 is properly met, and if the necessary supporting documentation envisaged by 10.3 has been provided and reasonable steps have been taken to minimize delay or damage. So I think it has been the way that the case has been put below, and it is our submission now that there is an obligation on the respondent to reasonably accede to a request for performance relief that's validly made.
Yes, but does that mean that Delta could not rely on 10.3 unless there is a forthcoming a consent from the respondent? Because the various requirements in 10.3 are fairly specific. You have to make the request in writing. You have to specify the reasons for the request with supporting documents. And you must prove that you took reasonable steps to minimize delay or damages. But I mean, provided you fulfill all of those requirements, what does the agreement of the respondent add to the situation?
Well, I presume it provides the certainty that there's been a meeting of minds as to whether the clause has been validly invoked. The word request implies an answer, and so it seems peculiar that the word request would be used in 10.3. If
Lord Briggs is the question, I think. Lord Briggs.
Yes.
You're not unmuted, Lord Briggs.
Yeah, there we go. I can see that a meeting of minds and the provision of information might be helpful to the buyer, who needs to know as early as possible if there's going to be a shortcoming in supply. Though I wonder whether the word prove isn't a reference to this all being about what then happens in any subsequent legal proceedings. But my real question to you is, granted that clause 10.1 is conditional upon the other subclauses of clause 10, the right to delay to withhold, reduce or suspend deliveries in clause 10.2, well, it's really clause 10.2 that has the guts of clause 10. And it isn't there said to be subject to being permitted to do so by a favourable response under clause 10.3. And if you just imagine a hurricane or something coming along and suspending your supplies, the idea that you couldn't exercise your right to reduce or suspend deliveries until you've gone through an elegant process of exchange of correspondence under and following clause 10.3 seems slightly unreal.
I can see that, my lord. The answer to the construction question that I would give would be that if you look at clause 10.2, because clause 10.2 itself refers back to clause 10.1 in the first sentence, if by reason of any of the clauses referred to in paragraph 1 above, that leads you back into clause 10.3. And I would answer the question about the realism of that approach simply by reference to what happened in this case. It is the case, as you will have picked up from the correspondence, but as perhaps you can most helpfully see by going back to a couple of paragraphs in our written case, that both the courts below were grappling with, when they were considering the appropriateness of awards of liquidated damages in relation to specific periods where the fuel in the tanks fell short of its required levels. At each stage, they were grappling with whether there had or had not been a specific request for performance relief in relation to that particular fuel delivery. And it's only when we get to the 1st of June 2015 that the appellant makes its request for indefinite performance relief, which, if validly accepted, would have meant that no individual discrete applications referable to specific periods of time would have been needed. Lord Sales has a question.
Yes, Lord Briggs.
I was just going to say, some of the earlier limited requests for performance relief that preceded June appeared to be about a shortfall in supply that had already occurred and was effectively asking after the event for or claiming performance relief by reference to the reasons why that shortfall had already occurred. Because I'm slightly worried that one possible consequence of your interpretation of an implied term, that there must be an answer to the request not to be unreasonably withheld, and until then you can't in any way suspend your performance, is that if that's right, then the whole of clause 10 would have to be operated, as it were, in anticipation of the expected event.
Can my lord just repeat that question? Why would it be the case that it would need to be operated on an anticipatory basis?
If you say that you can't reduce your performance, which involves keeping these tanks full with X number of days of supply, without first having asked for relief and got it, then it would follow, wouldn't it, that if the right to reduce performance is dependent upon the reply to your request, the process of requesting relief and getting it could never take place after the shortcoming in performance. And that seems inconsistent with the way that the earlier limited requests were made. I'm not sure the correspondence includes any response to the requests.
I think it does, sir. There are a number of letters in which requests are refused. Can I take, not seeking to sidestep my lord's question, but can I revisit it in a moment? The paragraphs in our written case that I wanted to take my lords to, which set out the history of the requests for performance relief that the courts were grappling with, are paragraphs 73 and 74. 73 is perhaps the most helpful starting point.
Do you have a page?
Give us the page number, please.
1098, I apologise.
That's all right.
And it might be helpful to, I don't know if this document is one that my lords have looked at yet, but there was a schedule of claim effectively attached to the particulars of claim. which my lords will find at 176. Sorry, 176 to 179, which is effectively the schedule filed by the respondent that formed the basis of its claim for liquidated damages. And that schedule sets out various periods where the tanks fell below the stipulated storage levels and the liquidated damages that were supposed to be referable to those periods pursuant to clause 3.7, I think it is, of the agreement. And so what the High Court in the first instance had to consider was, because of the interplay between clause 3.8 and clause 10, my lords will remember that clause 3.8 is effectively subject to clause 3.10, such that the entitlement to liquidated damages falls away where clause 10.1d applies. That's the last sentence of clause 3.8, page 880, except where the provisions of clause 10.1d apply. So there is a proviso which says that if clause 10.1d applies, then the normal entitlement to liquidated damages doesn't apply. The analysis that the High Court therefore engaged in was whether there was a valid request for performance relief in respect of each of the periods where, absent a request for performance relief being valid, liquidated damages would have been payable. And what you see at paragraph 73 of our written case, I apologise, I'm jumping around, I'm back on 1098 now, is a summary of the High Court's findings in relation to each of those periods. And you will see that the High Court did go rather forensically through this, looking at, in respect of each of those periods, was there a specific request for performance relief in relation to that specific period of shortfall? Was that request valid? And what was the consequence of that for the liability to pay any liquidated damages? So the courts below, and to the extent the Court of Appeal disturbed the High Court's findings, you can see that it was quite limited. Paragraph 74 of our written case identifies that really all the Court of Appeal did was in relation to one period from the 27th of April to the 3rd of May, overturn the High Court's finding because, in fact, there had been an attempt to seek performance relief, which the High Court had overlooked. So there wasn't a great deal of disruption of the High Court's findings. And standing back, therefore, what you see is that both courts below did approach the question of performance relief as something which required a request to be made and something which required that request to be valid. And they effectively approached the question of validity by reference to whether or not the respondent had replied to say that it was refused or not.
Can I just take you to your paragraph 76 of your case on page 1099, where you say that the shortfalls on the 29th and 30th of May, forget the 8th to 12th of June for the moment, was the subject of a valid request for performance relief made on the 1st of June. Now that seems to me to be saying you can make a reduced performance, namely the one that occurred at the end of May, and make your request for relief about it after you've actually reduced your performance. So that the reduction of your performance is not ipso facto a breach merely because you haven't got consent in advance.
Yes, I think the approach that's been taken is there consent rather than is there consent in advance?
Yes.
Lord Sales.
I come back to my original question. Why does it matter? Why have you suffered any loss under a contract if your right to reduce your performance is not itself dependent upon having got a consent to do so?
Perhaps some of the answer can be found in the interplay between the liquidated damages clause and the performance relief. I don't know if that's of assistance. Because the performance relief, if properly obtained, effectively deprives the respondent of the liquidated damages to which they would otherwise be entitled. Perhaps that is some answer as to why it is important that there is a meeting of minds on the point.
Now, Lord Sales.
I just was looking at clause 10.1, page 889. Rather triggered by Lord Briggs's point about operation in anticipation, or when exactly you have to make the request. It seemed to me that 10.1 is not specific as to whether the request has to be made in advance of the obligation falling due or may be made afterwards, because it's put in terms of whether the seller or buyer is responsible for any failure to fulfill their respective obligations, which I wondered whether that applied both ways round, and might be taken to indicate, in line with your submissions on clause 10.3, that the trigger for non-responsibility is acceptance of non-responsibility, and that the contractual mechanism, if that consent is not forthcoming when it should be, is a claim for damages under 10.3.
My lord, I would gratefully endorse that analysis. Excuse me, one moment. Yes, and perhaps to support the analysis that my Lord Sales has just suggested, my learned leader points to the fact that the last line of clause 310 contains the language of notification of the likelihood or actual occurrence of an event.
Which page are you on?
I'm on clause 10.3 of the agreement 890, which would suggest that notification can be either prior or after the happening of a particular event.
Yeah, I'm not sure that helps terribly
It may not.
this, because in order for the various subparagraphs in 10.1 to apply, you need a causal connection between the effect that it's had on either the buyer or the supplier, as the case may be. So your right, I would have thought, usually only arises once the right to claim performance relief usually only arises actually once the event has occurred.
My lord, yes, I think I would accept that.
Thank you very much anyway.
So to return to the basis of the counterclaim then, and I will come on to deal then with the questions that have been raised about the recoverability of that counterclaim thereafter. That, I hope, provides some explanation as to why the counterclaim was put on in the way that it was, namely that it was on the 1st of June that the appellant made its request for indefinite performance relief, and it was the respondent's refusal to accede to that request for indefinite performance relief, which was the relevant breach, which gave rise to the counterclaim. That's how it's put in the defence in the paragraphs that I've taken my lords to. The loss and damage stated to flow from that counterclaim was then stated to be the failure to provide the requested performance relief, as well as the loss flowing from the obtaining of an interim injunction compelling the supply of fuel at an uneconomic cost. And that's how it's put in the defence, of course, because at that point in time, there was only an interim injunction in place. To deal with, I think it was a question. So sorry, just to come back to the point of breach. I've said that the breach was therefore the respondent's refusal to accept the request for indefinite performance relief that was made on the 1st of June in accordance with clause 10. That refusal can be located in the respondent's letter of the 4th of June. And that is at page 1001. So that is the basis on which the counterclaim was put. One of the questions that's been posed is, well, what is the impact of the fact that the court's order for specific performance has effectively intervened following the respondent's refusal to grant that indefinite performance relief? If I understand my Lord's concern correctly, my Lords contemplate a difficulty in claiming losses that might be said to flow properly from the order of the court, absent the existence of a cross-undertaking in damages. I have 3 submissions in response to that.
Can you make them fairly quickly, Ms. Patel, because we are very short of time?
My Lord, yes. The first submission is that the respondent has never taken issue with the fact that such losses properly flow from the counterclaim. I'll just give my Lords a reference. Paragraph 76 of the respondent's High Court skeleton on page 276.
Yes.
Secondly, in my submission, the order of the court doesn't alter the fact that the losses flowing from the order were foreseeable upon the respondent's breach and subsequent issue of proceedings. So the losses might be said to fall within the normal rules on remoteness and recoverability, because it was foreseeable that the respondent might issue proceedings and might succeed on its claim and might obtain specific performance. Thirdly, just to deal with the cross-undertaking in this case, my learned friend Mr. Dennis has taken you to the cross-undertaking, which is found in the order granting interim relief at 141 of the bundle. In my submission, that it is arguable that properly construed, that cross-undertaking should be read as extending to the grant of the final as well as the interim injunction. Because were it not for the order is referable to losses flowing from the making of that order. And it could be said that those losses include the making of the final order, because had the interim order not been made, the final order would not have been made. I have to accept, my Lords, that there is no separate implied cross-undertaking. No separate cross-undertaking that was made at the point that the final injunction was made. I think all I can say, my Lords, on that point is that arguably there is a basis for implying one on the basis that, as I've indicated, the respondent did not take issue with the fact that the losses from specific performance flowed from the appellant's counterclaim. Had there been any issue as to whether the respondent would be willing to unwind a final order if an appeal found the final order to have been wrongly made, I think it's right that the appellant would have sought a stay of the injunction pending its appeal to the Court of Appeal, because otherwise it would have suffered irreparable harm. That wasn't done. So it was the understanding as between the parties that at the point the final injunction was made, no such stay was necessary, because were the final injunction found to have been wrongly made, there was no issue taken by the respondent as to the appropriateness of unwinding the relief. My learned leader has just asked me to ask my lords to turn up 276, which is the paragraph in the respondent's skeleton where they say that they don't take issue with the measure of damages flowing from the counterclaim. It's page 276 of the bundle, paragraph 76. In the unlikely event that the court finds the corporation is in breach of contract, the measure of damages would be limited to the difference between the contract price and the price as adjusted to take into account the increased costs of supply. It might be that my lords consider that that is a succinct way of resolving this issue. Can I finally deal with the last question, conscious of the time, as to whether my lord...
2 minutes, Ms. Patel, no more.
My lord. My lord Hamlin asked yesterday whether if there was a repudiation by the respondent justifying the counterclaim, it was accepted by the appellant. The appellant's response is that the repudiation was accepted by the appellant and the agreement did accordingly terminate. But we do say that the question of whether the breach was accepted does not matter for the purposes of the validity of the counterclaim, which I hope may answer the question posed by my Lord Sales yesterday afternoon. As to where that acceptance of the repudiatory breach can be found, the appellant's primary position is that that acceptance can be found in the letters of the 5th and the 11th of June, pages 1003 to 1013. Those documents read as an acceptance of the prior refusal to grant indefinite performance relief and a termination of the agreement subject to a willingness to continue to supply fuel on an interim basis only. Hence the references in those documents to the appellant's willingness to participate in a new tender. There is an alternative position available, which I just raise in case my lords are attracted by it, which is that the acceptance might be located at an earlier stage in the 1st of June letter itself, by reference to the respondent's insistence in its 30th of May letter that the appellant continue to perform the agreement on the same terms, notwithstanding the Havensa failure. That is not, I have to accept, consistent with the pleaded case that was put forward in the defence. I raise it because my lords may think that that is a better reflection of what the documents show, but that is not how the case was put below. I do say finally that the question of whether the agreement was terminated is not germane to the question of whether there is a valid counterclaim. The entitlement to damages arises notwithstanding that. But if my lords are interested in the question of termination, I just note to my lords that paragraph 11C of the grounds of appeal, which I think was filed at the registry loose copy yesterday because it didn't make it into the electronic bundle, makes the point that a ground of appeal is that the courts below erred in their application of the principle of waiver by election because clause 10 did not preclude the appellant from exercising its common law right to termination. And of course, that would be consistent with the submission that I now make, which is that there is a proper basis for finding that the agreement did terminate at common law in early June.
Thank you. Thank you very much indeed, Ms. Patel. We're very grateful to you and to all who have participated in this hearing. The board will take time to consider its opinion. Thank you very much indeed.